Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? The EEOC's final regulations and interpretive guidance implementing the Pregnant Workers Fairness Act provide important clarifications and insights into how the EEOC will enforce the law. Effective June 27, 2023, the PWFA requires employers with at least 15 employees and other covered entities to provide reasonable accommodations to a qualified employee's or applicant's known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless the accommodation will cause undue hardship on the operation of the employer's business. On this episode of We Get Work, we discuss the EEOC's final rule, identify how the final rule differs from the proposed rule, and offer guidance on compliance strategies and clarify changes, while specifically addressing questions raised during our May 10th, 2024 webinar. Today's hosts are Joe Lynette and Catherine Weber, principals and co-leaders of the Disability Leave and Health Management Practice Group. In their joint role, Joe and Catherine help employers manage employees who request accommodations and leaves of absence due to disability, pregnancy, childbirth and related medical conditions, serious health conditions of themselves or family members, religious beliefs, military service, and other reasons protected under state and local laws. Joe and Catherine, the question on everyone's mind today is, how can I comply with the new PWFA regulations, and how will those regulations impact my business?
Hi, my name is Joe Lynette. I'm here with my partner, Catherine Weber. We're from Jackson Lewis, and today we're doing a podcast addressing some really interesting questions we received during a webinar that Catherine and I gave discussing the PWFA final regulations, the Pregnant Workers Fairness Act. Now, typically, Catherine and I would address these questions during the webinar itself, but there were 2,000 people attending this webinar.
And I think we had about 2,000 questions too.
Yeah, exactly. And so we realized pretty quickly that there was no way that we could ever possibly do justice and answer even a fraction of those questions. So we decided that we'd have a whole separate podcast talking about kind of the questions that we received and how to resolve them, because the PWFA is a new law, and employers are really trying to understand how to comply with it. There are some roadmaps that employers have typically used to try to comply using their ADA accommodation process. But as you'll kind of find out that the PWFA is different, a different objective than the ADA, some more restrictions on the types of information you can request. So it doesn't so easily translate into an accommodation process for the PWFA. Right, Catherine, would you?
Yeah, no, I completely agree. And in fact, I think that when you take a look at the final regulations that were issued by the EEOC, I would say that the one big knockout punch, if you will, that we found in the final regulations is that the EEOC really has no use for our, trying to basically use our ADA medical questionnaire forms and our typical forms and processes and lay that on top of the PWFA. They really do envision that we're going to handle these requests in a different manner. Now, that doesn't mean that we can never ask for medical information at all. It doesn't mean that we can't have a process in place. In fact, we should. It doesn't mean that we can't have template forms. Those are all great ideas too. But the process that we're going to use under the PWFA looks very, very different and is almost the opposite approach of what we would take under the ADA. So, we'll talk about that process and how it differs from the ADA and just that very practical, lens, if you will, about how you would actually walk out and administer the PWFA as compared to the ADA. But first, Joe, I've got a couple questions for you. And I promise I won't ask, I promise I will not ask you all 2,000 that we got, right? But I am going to start with just a level set for our folks. We got a few questions where people were asking us about the length of time that an employer has to accommodate somebody for either pregnancy, childbirth, or a pregnancy-related medical condition. And I think a lot of people expected that there was going to be some time limit around when the employee would have to be accommodated, maybe, 3 months before they delivered to 3 months after they returned from work. But that really didn't turn out to be the way the EEOC wrote their final regulations. So, Joe, is there a length of time after delivery of a child that the employer has to continue to consider requests for accommodation under the PWFA by an employee?
Yeah, we received a lot of questions about this particular area. Because, commonly, I think many people regard accommodation of pregnancy as the accommodation period during pregnancy and for perhaps even the 6 to 8 week period post childbirth recovery. But the PWFA makes clear that there really is no defined length of time. There's no end date to the time in which employers are no longer required to consider accommodations related to pregnancy. And that in large part is due to the vast amount of conditions that can arise out of pregnancy well after childbirth that are related to pregnancy. So the short answer, Catherine, is that there's no per se end date. And employers may be in a situation where they will have to consider accommodating pregnancy-related conditions long after the employee has given birth and even has recovered physically from the childbirth.
Sure. And in fact, the same can be said of before the pregnancy too, right? And I think all of that really relates to the fact that the way the EEOC defined pregnancy, childbirth, and related medical conditions is far broader than, what I think most people would expect. And so, certainly for a current pregnancy, we're talking about 40 weeks, right? But any sort of an accommodation request that's, before somebody gets pregnant or after they return to work following childbirth, there's no time limit on that, right?
No.
Okay.
It's a question of causation. Is it caused by pregnancy? Is it related? Did it arise out of the pregnancy?
Or certainly there are some, or one of those related conditions, right?
Because certainly, there are conditions that can be exacerbated by pregnancy and childbirth that occur commonly throughout the population amongst women who aren't pregnant or not caused by pregnancy, like carpal tunnel, for example.
Right. Absolutely. So, I think that there are things that we would commonly expect with respect to somebody who's pregnant, right? We would expect them to have some morning sickness. We would expect them, maybe they would have some back pain or some swelling, or maybe they could have carpal tunnel, right? If they have enough fluid buildup that starts to impinge on, nerves in their arms, et cetera. And you could certainly get a pregnancy related case of carpal tunnel. But, when we look at how the EEOC addressed what constitutes pregnancy, childbirth, and related medical conditions, some of the things I think that, are up for grabs or up for debate, if you will, when we get into the litigation are going to be things like, is menopause covered? Right?
Well, maybe, right? The EEOC says you need to look on a hormonal level, right? Whether the pregnancy has or childbirth has altered the hormone levels that could impact on the severity of menopause. Right.
Well, what about menstruation? I think we just saw that the EEOC, put out some piece last week about menstruators, right? Clearly they think that menstruation is connected enough to be a pregnancy related medical condition. Right.
It's going to depend on the medical opinion of the employee's healthcare provider, connecting the pregnancy, childbirth to a medical condition which occurs naturally, right? Menopause is a natural part of human life as well as menstruation, that may potentially be covered. Menopause, by its very nature, may be covered long after the employee's childbearing years, right?
Right. And then we have things, the EEOC suggests that things like IV, fertility treatments and abortion, postpartum depression and anxiety, all of those things, fall within the examples that the EEOC gave to us as potentially something that might be considered protected, limitations under the law. So it'll be interesting.
I mean, it really, and the big takeaway there is that there are a vast array of conditions that the EEOC specifically identifies as possibly covered under the PWFA, right? So it's really going to come down to, can the employee's healthcare provider make a reasonable connection between the current medical condition, could be a psychological condition too, and the pregnancy.
Right. And or just the limitation, right? I mean, because we know we don't have to, a specific medical condition necessarily if it's just a limitation arising out of the pregnancy or the childbirth. Well, here's a fun one for you, Joe.
Yeah.
So what kind of protection do men get under the PWFA?
I think very little in terms of accommodation. There was some, one question we got is, would men undergoing fertility treatment be covered? Well, not their own fertility. Well, I suppose that is their own fertility treatment, but probably not. How about if a man were undergoing fertility treatments, and having side effects? Can they request an accommodation under the PWFA? Catherine, sort of my view on this, and I think it's consistent with the EEOC regulations, is that it protects, the PWFA protects pregnancy, childbirth, and related medical conditions. It is gender specific. Men, on the other hand, a man in this situation, while not protected under the PWFA, may be protected under the ADA, right?
Right, or the FMLA, right?
Or the FMLA, right? If they need time off, sure.
Or I guess we could even have state, paid sick leave law coverage of that issue. But I see the PWFA as very similar to the ADA in that regard, right? I mean, under the ADA, the law does not require us to accommodate a family member who has a disability.
Right.
And under the PWFA, the law does not require us to accommodate a family member who has some condition that's related to the employee's pregnancy, childbirth, or related medical condition. So I think that's an easy way to remember it.
Yeah, I think that's right. So, Catherine, let me ask you, we've dealt with, we've discussed questions around, what medical conditions are covered or possibly could be covered. I think we got a bunch of questions, practical questions from attendees on kind of reasonable process, best practices. How do employers, what are your thoughts on how employers should go about addressing accommodation requests under the PWFA? Because a lot of the questions we've gotten, a lot of what I've read just out there in the literature is that a lot of employers are of the view that they can either tweak or just use their FMLA process, their ADA process to evaluate accommodations under the PWFA, just like they evaluate accommodation request under the ADA. What are your thoughts on that?
So I think that we've done a great job as an employer community, trying to be consistent about how we handle accommodation requests covered by the ADA. But I think that we have to absolutely, stop using that as our default setting. That is no longer your default setting when it comes to the PWFA. When it comes to the PWFA, what the EEOC makes clear is, look, if you're using your ADA forms, your accommodation forms, and that medical provider request for information form under the ADA that you may have developed, it may be a fantastic form, but it has limited utility under the PWFA, because under the ADA, those questions are all related to whether or not somebody has a physical or mental impairment that substantially limits a major life activity. But that is not the test under the PWFA, right? I mean, under the PWFA, we only need to know whether or not the person has a limitation due to pregnancy, childbirth, or related medical conditions. So if we're asking our employees to have their healthcare providers fill out that ADA questionnaire, we're likely asking for information, A, that's not even on target, and B, is more information than we're entitled to receive. So, and the other part, as I said, we've done a great job of getting our consistency down pat, and we have this default setting of person asks for an accommodation, we're going to give them the healthcare provider form, and we're going to ask them to have the healthcare provider complete that form and return it back. But under the PWFA, what the EEOC envisions is that the employee will let you know that they're limited due to pregnancy, childbirth, or related medical condition. And then if it is one of the 4 predictable assessments or it's lactation, then you're going to quickly provide it, right? You don't need any additional medical information in order to grant that accommodation request. So, and to be clear, by the 4 predictable assessments, if the person is asking, for the opportunity to carry or keep water nearby and drink, or if they're asking for additional restroom breaks, right? Or if they're asking for the ability to sit when their job principally requires standing or vice versa, or they're asking for breaks to eat or drink while they're pregnant. All of those things fall under predictable assessments, and we don't need medical information in order to grant those. And the same thing would be said of lactation, as well, right? So the only time we really get to ask for medical information is when the condition is not obvious, like the pregnancy or the childbirth is not obvious, and the extent of the accommodation is not known.
Yeah, and that's really different, right, than the ADA process, where I think employers are almost, as just a matter of course, request medical information, because oftentimes a disability is not so obvious, right? Whereas pregnancy is, when we're talking about, an actual pregnancy. So I think, reading the final regulations, it seems like the message that the EEOC is sending is that, you shouldn't be spending a lot of time requesting medical input, right? Especially due to kind of, in some ways, the urgency of some of the accommodation requests that we're talking about, right? These 4 predictable assessments that you mentioned before. These are kind of address more urgent needs, right? Additional bathroom breaks is needed, keeping water nearby, sitting instead of standing, breaks to eat and drink. Your typical ADA accommodation process, even under the best circumstances, usually takes place over the course of 30 days. And that's when there are no glitches. But so for something like these predictable assessments, you can't, it would be almost cruel, right? To wait 30 weeks while the accommodation process works out. So, it sounds to me, Catherine, like employers need to rethink their accommodation process under the PWFA. Certainly, employers, I think, have gotten accustomed to the ADA process and the interactive process under the ADA, but it doesn't seem to translate so well or too perfectly into the accommodation process under the PWFA. And in fact, as you point out, may cause an employer to run afoul of the law. Right.
Right. Because you're asking for more information than you're entitled to receive. Right.
And that's not even considering state and local law, right? Because there are a host of state and local laws that place even more restrictions, even more explicit restrictions on an employer's ability to request medical information to evaluate accommodations related to pregnancy and childbirth.
Right. I mean, I think my last count was 13 jurisdictions, state and local jurisdictions that will limit, when an employer can ask for medical support when it comes to a pregnancy or childbirth related accommodation request. And I'm sure that number will continue to grow, right? I mean, the state and local legislatures are very active in this space. Not only are we seeing it in the accommodation space, but we're seeing a lot of action in terms of, paid lactation breaks, right? I mean, we've got a couple jurisdictions now that require that those breaks be paid. But one thing that I saw from a recent scenario I thought was really interesting. I had an employer who had really done a wonderful job in terms of, instead of starting with forms, they started with a conversation, right? And they had this wonderful conversation with the employee about what is it that you need and how will it help you? And, how long do you think that you'll need it? And, are there any other alternatives? They had this great conversation. Essentially, they were just having a dialogue with the employee about the information that you really wouldn't otherwise be able to ask of the doctor in the way of getting a form, but they were just gathering that sort of information from the employee so that they can make a good decision with the employee about what kind of accommodation they needed and for how long, and whether or not there were any alternatives that might work. And I think that that's a wonderful practice to adopt. It's gonna take some trial and error to get it right, but I think all of that really it's going to come down to great training for your HR professionals and also letting your managers know when they should be triggered. And I say that in a good way, triggered to let HR know that there is a PWFA request that's been made and they need some assistance in terms of properly handling it.
So, Catherine, one maybe even the last bucket we have time to talk about of questions relates to lactation breaks and pumping in the workplace, and how that interacts with the Pump Act, right? Which has been on the right to a lactation break has been, been on the books for several years. And the PWFA requires accommodations related to pregnancy, and lactation and pumping is a condition related to pregnancy. But, it was interesting. One significant change, substantive change that the EEOC made from the proposed regs to the final regs was this accommodation related to nursing, which is different than pumping. It's actually nursing, breastfeeding in the workplace, right? So there were questions around, what is the scope of that accommodation, right? Because the Pump Act, creates a right to break to pump. Doesn't necessarily state that it's nursing. But the EEOC explicitly added nursing to conditions, lactation conditions that employers must accommodate. What do you have to say about that? What should an employer think about that?
Sure. Well, so, the EEOC really did kind of cross lanes, if you will, with the Department of Labor when they added lactation as something that would have to be potentially accommodated under the PWFA. It's certainly not out of step with how we're looking at the definition of pregnancy, childbirth, and related medical conditions. We have seen the case law for years and years and years that lactation is related to pregnancy under the Pregnancy Discrimination Act. So this is not a great shocker, right? But I think when the EEOC goes in and then they add or they layer additional accommodation obligations on, it gets challenging for employers. And I think the big one, that they layered on top was this right. If the employee has proximity with their child and they want to they want to nurse in the workplace, then the EEOC says that could be potentially a reasonable accommodation under the PWFA. So, you think about, perhaps, you're an employer and in your building there's a daycare provider, or you're a healthcare provider and there's space, already set up where people can pump, right? Those are situations, I think, where it's going to be really easy for the EEOC to say, well, certainly the child can be in close proximity, to the nursing mother. And, certainly there could be the right to actually breastfeed in that setting. I don't think that they meant to suggest that there's this right, you get to automatically stop your work at this hour and run 20 minutes to your house and pump from your home and then come back. I don't think that that's what they were saying at all. So I don't think that they were saying that the employer has to create the proximity. But if the proximity already is available or it's already existing.
Right. I think that's right.
That's where the EEOC views it as a potential accommodation.
Yeah. So I think that's right. That there's no right to proximity. Proximity is a sort of a condition, if you will, to evaluating a request to nurse, right? That the infant already needs to be in close proximity. The accommodation isn't meant to create the proximity.
Absolutely.
But you're right. It's going to occur in situations where the employer may be providing, daycare on site. Certainly, it's going to occur at home, right? where presumably the child is already in close proximity. So, but I think that another takeaway here is that it just adds another layer of compliance and potential claims, right? For by an employee that they were not accommodated due to pregnancy, that their need to pump or lactation breaks were not accommodated, and it could be potentially violative of both laws, both the Pump Act and the PWFA.
Right. And, I think all of this is so new still for employers. I mean, granted, the law has been in effect since June of 2023, right? I mean, it was enacted late December of 2022, went into effect in June of 2023, but we just recently got the final regulations. So it's going to take a while for employers really to get up to speed and to get really good at accommodating people who make requests for changes in how they work or policies or other types of accommodation requests under the PWFA. But eventually we'll definitely get there, just the same way as we got there under the ADA, right? I mean, when the ADA was enacted, everybody went, oh my gosh, how are we ever going to come into compliance with this law that's going to require so much different from, so many things that are different than what we're normally used to doing. But, this will come to us naturally as well.
Yeah. Well, I think our time is drawing to a near, Catherine. We're going to see how this all plays out over the course of the upcoming years, and particularly, I think the first few years, a new law is in effect. The courts and the agencies really do create a scope of interpretation around how the law applies, where it doesn't apply, the limits of employers' obligations, and so forth. So it will certainly be a story in progress.
That's right. That's right. So for folks who want to keep abreast on the new developments under the PWFA, as cases, are decided, make sure that you're following our blog, make sure, that you are keeping up to date on this space so that you can make sure you're making great decisions when it comes to accommodating your employees under the PWFA. Thanks so much for joining us. This again is Catherine Weber and Joe Lynette with Jackson Lewis. We've enjoyed our time together.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.